welcome back to our channel Low Point. This is Aisha Babu. There are three pillars to democracy. The first is legislature to make laws. Second is executive to execute the law made by the parliament. And finally, judiciary to interpret the law. Likewise, the Parliament passed the Domestic Violence Act in the year 2005. It is the judiciary's interpretation of the provisions of the Act that lends more meaning to the Act. We have a Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph, to discuss about the relevant landmark cases decided by the judiciary under the Domestic Violence Act. So let's watch.
Our first case is Nihal Banani versus Tanya Banani, decided on 22nd of July 2019 by the Honorable Supreme Court of India. Here, the family court directed the husband to pay maintenance per month to his wife under section 125 of the Code of Criminal Procedure. Even then, the wife went ahead and filed an application for monetary relief under the Domestic Violence Act, wherein the magistrate court rejected the application on the ground that she was already being granted maintenance by the family court. Not satisfied with that order, wife filed appeal before the Honorable High Court, wherein the Honorable High Court ruled in her favour, holding that merely because maintenance was granted under section 125 of the Code of Criminal Procedure does not mean that the wife cannot seek additional maintenance under Domestic Violence Act. This time, the husband, who was dissatisfied with the High Court order, approached the Honorable Supreme Court, wherein the Honorable Supreme Court also ruled in favour of the wife on similar grounds. So, in short, the takeaway from this case is that beneficial reliefs under Domestic Violence Act are independent, and any additional reliefs from other statutes can simultaneously be applied if the parties file for both. Our next case is Sadhana versus Heman, decided on 18th of April 2019 by Bombay High Court. Here, husband and wife were granted divorce by family court on 30th of June 2008. And after 1 year, in the year 2019, the ex-wife filed domestic violence application against her ex-husband. The magistrate court dismissed the application on the ground that at the time of filing the domestic violence complaint, both husband and wife were divorced and there was no domestic relation between them. Being aggrieved, wife moved before the Bombay High Court, wherein the Bombay High Court rejected the wife's petition on similar grounds and held that divorced wife cannot be entitled for protection under the Domestic Violence Act. Our next case is Vijayanand Naik versus Vishwandi Vijayanand Naik, decided on 17th of March 2019 by Goa bench of the Bombay High Court. In this case, wife along with her minor son filed domestic violence petition against the husband, the father of the minor son. However, the magistrate court found that there was no domestic violence committed by the husband, the father of the minor son. Even then, the magistrate court directed the husband, the father of the minor son, to pay monthly maintenance of rupees 5,000 to his wife and child. On husband's challenge, the Goa bench of the Bombay High Court held that any act of domestic violence is the basis for the magistrate to grant any relief under the Domestic Violence Act. And in the absence of any such finding of domestic violence, the magistrate cannot order for the relief of maintenance under the Domestic Violence Act. Our next case is Sadeshchandra Ahuja versus Sneha Ahuja, decided on 15th of October 2020 by the Honorable Supreme Court of India. Before going into this case, it's important to note that right from the beginning, the Domestic Violence Act maintained that women has right towards a shared household, irrespective of her having any legal interest in the same or not. However, the meaning of shared household was very narrow in nature, that is, only the husband's property or the joint family property where husband has a share would be called as shared household. But in this case, the court broadened the meaning of shared household by adding that it is not only the husband's property or property where husband has a share, but also the husband's relative's property can also be a shared household provided wife was staying with husband and his relatives in a domestic relationship on some permanent basis. Further, if the woman feels threatened by her husband in the shared household, the magistrate court can even direct the husband to leave the house and stay in a different place. It's important to note that the court refused to pass such an order in case the abuser is another female family member. Our last case is Hiral P. Hazora versus Kusum Naruto Hazora, decided in the year 2016 by the Honorable Supreme Court of India. In this case, mother filed a domestic violence complaint against her two daughters, her son and her son's wife. Now, an application was moved by son's wife and two daughters for releasing them from the case, stating that domestic violence complaint can only be filed against adult male member and not against female members, wherein the Honorable High Court discharged the three female accused from the complaint. However, in appeal, the Honorable Supreme Court set aside the High Court order and held that domestic violence complaint can be filed against female accused as well who were in domestic relationship with the aggrieved woman. Thank you.
Thank you for watching. Stay tuned. Till then, take care. Bye-bye.